Oh, okay. So do I need to go through the motion and then get an updated report?
Not if you're not if the court needs it.
Okay. I guess my only, before you even tell me what it is, I'm probably going to want all the information on what he's been doing and new offenses, but
Here's where things get tense. The court is weighing whether Safe Pete is appropriate. Notice how probation history and prior felony cases play a massive role here. This is the kind of decision that can change someone's entire path. Would you risk it on a program like Safe Pete, knowing the stakes?
tell me what you think.
We are, we can say, I've been correctly liar to put on probation on the two felony cases. That's another challenge. I'd also extended the time offer for 3 years. Should consider preferences to support alone and do something. We have a lot of count here. Just the court is aware originally this interpreted was filed when he no show in judicial review in November 4th. And shortly after that, November 25th is the office date to Smith County case. So that's the first one. This was for the second.
So, in safety, is there?
This is crucial. He pled guilty to assault and threatened someone with a knife. From a legal standpoint, these are serious felony charges that can heavily influence sentencing. It's not just about probation anymore. We're talking about balancing punishment with rehabilitation.
Yes. What is the allegations for why safety would be appropriate? Is there a drug issue?
Yes, in September and October, there is on count 6, the allegation that he was intoxicated.
Judge, I'll tell you, County cases arranged with altercation with a girlfriend and a friend or a friend exposed to feels it is, but because the time was acting, threatened her and put him off. And then assault the other. And that's going to believe it's put guilty to offense probation and civil powers. So obviously there's a drug issue. His history is juvenile for what we're hearing now and for what he did. Smith County, all of all assaults, considers college of violence.
And I do think.
Whoa, check this out. He got a black eye in jail. That's a raw moment showing the realities inside. The tension here isn't just legal, it's visceral, personal. Jail incidents like this can sway how judges view someone's readiness for programs like Safe Pete.
Safety would be appropriate as well, Your Honor, because in regards to the November 4th date, which he failed to appear for his administrative hearing, he was in the hospital due to some self-harm. And so that was the reason why he did not appear on that day, because he was in the hospital.
So whatever the court wants to do with filing, we're just going to let you know what we thought.
You have a black eye. Got into a fight in jail. Yeah, you just.
What would you get? 400? You know, you want to do this.
Yeah.
So if I somebody fell something in front of you, you go on. And that's right. Maybe just can't, last 2 weeks off that. More than one disrespect we go.
The judge really hits hard here. She's saying, take responsibility or face the consequences. It's a reality check. Pause and think, how often do we get chances in life and still choose the wrong path? Drop a comment if you think accountability really changes behavior.
So, Dan, why don't you tell me why you think I should not put you in prison today? And so here's the thing, you've been coming here for a while. And I've read about and we've talked about and I understand somewhat and empathize with what you've been through and where you come from and the issues that you've had to deal with. But at some point, you have to take personal responsibility for the rest of your life and the circumstances of your life before. You have to be able to say, you know what, that was awful, it was great, it was fair, but I'm going to do something different and I'm going to quit doing the same thing over and over again and kind of blaming that didn't have a great upbringing like some other people maybe. Does that make sense? And it's going to be no one's fault at this point but your own. You will be given, you already were given here, all kinds of opportunities. And I'm very hesitant to go along with this. Because what you're doing is not just using drugs.
Here's the fine print no one talks about. Even if he goes to Safe Pete, incidents before or during the program can immediately violate probation. This is why judges stress compliance. It's a tightrope. One misstep, and it could send him straight to prison.
And not showing up. It's the violence that I have concerns with. And that at some point, I don't want it to be on me that I let you out, that you really, really hurt somebody or killed somebody or got yourself killed. Because that's where this is headed. And I understand that, was it Tyler County has given Smith County. So what about the Tyler County?
Correct. It should
Oh,
Tyler, Texas, but Smith County.
City College, Smith County.
so what? So what they did in Tyler by giving you that opportunity kind of puts me in a position where if you're on probation there and I give you some amount of time, you're still going to get out and be on probation. I understand why Mr. Nichols and Ms. Holmes have come up with this agreement. But I want you to understand that if I send you to safety, two things, and you're not the first person I've said this to today. You're going to have some amount of time while you're waiting in our jail to go to safety. And then once you get to safety, you're still incarcerated. And any incident reports that happen, any incident in our jail or safety is going to be a violation of your probation before you ever get back out. And I won't care what they're doing, Tyler. I don't care if they keep you on probation. You'll be done here. And it's not going to be for a little 3-year sentence. Do you understand that? So this is the opportunity. Those people at the jail that are working there and just trying to go do their job every day do not deserve for you to speak to them the way you do, treat them the way, to not follow the rules. You know, I mean, I'm not going to say on the record, but I mean, I guess my concern, if you really don't want to be in jail, the way you're talking to some of these people, like, I don't give a, if you write me out, you can't tell me what to do kind of stuff, doesn't make me feel like you're really going to be able to do this. If you really want to, it's up to you. Just a mindset change. You're going to be given the opportunities, but I want to know, you know, we'll be checking, my staff can check every day until you get to safety. Anything else happens, they're going to file a motion to revoke, and we're going to be right back in here within a couple of weeks if necessary. Do you understand? This is your final chance. Like this. Come back in and no excuses after this point. If somebody else gives you another chance in another county, that's on them. You're not getting another one with me. I want to go through the motion, though, because I want record of what he either pleads true or not true to, so that I know kind of when I look back what we talked about and what we did and what was pled to before I agreed to anything. So, Mr. Wizard, the best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, put your hand down. And will he waive the formal reading of that motion?
Yes,
And so before we go, Mr. Nichols, did you want to make a amendment?
Okay. I will drop count 1, the failing to appear bedroom based on the conversation I had in his home.
Okay.
And then count 9, one count 12, and counting what company Captain Charles and Captain Smith on the one count.
Any objection? Okay.
Correct. Yeah, I think that's all I'm saying.
All right, thank you. So, Mr. Wizzett, I'm going to go through this motion. It shows in cause number 240198, you were placed on probation July 1st, 2024 for the offense of injury to a child, elderly, or disabled individual. And that was a 3-year deferred probation. Is that correct? And I guess also, I'm going to go through this, but I am inclined based.
As the counts get read one by one, you can see a pattern forming: substance issues, violent behavior, missed obligations. The judge is meticulously laying out the record. For viewers, this is a masterclass in how cumulative offenses influence sentencing. It's about piecing the puzzle together.